Started the profession, I have seen planes running to about 2-3 pages. And that was a time when witness action took place in the court halls in the original site in Madras High Court. Immediately after evidence is completed, the judge will hear the arguments of both the sides and start pronouncing the judgment in open court. That was the kind of experience. But today we don't have that kind of situation. I think we have all become so used to the cut and paste that we now have planes which run to 50 pages, 100 pages. We are not precise and concise in our thinking. Written statements run to the same length or more. There isn't much attempt to make full disclosure of all the documents. This was the kind of situation that we reached towards the end of the last century. In 2002, substantial amendments were made to the Code of Civil Procedure. And these were challenged by various bar associations, including the Salem District Bar Association. And the court had appointed me as an amicus curiae to defend the amendments or to point out what are the weaknesses which need consideration, either for modification or for striking out. And I had assisted the court, and that is reported as 2003 Volume 1 SEC 49. During the course of the hearing, the Chief Justice of India, the then Chief Justice of India, Chief Justice Kripal, felt that there was a need to appoint a committee to look into how the procedure contemplated by Section 89 for arbitration or mediation when a civil suit is filed is to be implemented. And the committee consisted of the retired Judge Justice Jagannath Rao, who was also the chairman of the Law Commission, two eminent lawyers who thereafter held the office of Law Minister, Mr. Kapil Sibal, Mr. Arun Jaitley, the then chairman of the Bar Council, Mr. Subbarao, and I was a member. And since the two persons who were senior counsel and very busy in public life could not attend very many meetings, the meetings were mainly consisting of Justice Jagannath Rao, myself, and Mr. Subbarao. And we submitted a detailed report, most parts of which are set out in the second Salem Advocate Bar Association case, that is 2005 6 SEC 344. Two parts have been set out in full. One part may not have been. That's in regard to alternative dispute resolution rules, mediation, conciliation, and also in regard to case management. These had been considered thereafter by Chief Justice Agarwal's bench, and most of them had been approved and recommended for adoption by the High Courts. When the first decision had been rendered, Justice Jagannath Rao, who had chaired the committee constituted by the court, decided to take up suo motu as chairman of the Law Commission the subject of having a separate stream of code, which was also one of the things that we had recommended in the committee's report, in regard to certain specified type of cases, the commercial causes. And therefore, he submitted the 188th Law Commission report in December 2003. The judgment in Salem Bar Association had come in sometime in September 2002, and a year and 3 months thereafter, this report of the Law Commission was submitted, 188th report. This was considered and the bill was introduced by Mr. Jaitley, but then it was referred to the Select Committee. Then it was not taken up for quite some time. It's only in 2015 again that it came up, and Mr. Jaitley again took the lead, and then we have the Commercial Courts Act 2015. Mr. Jaitley had vast experience as a lawyer in Delhi High Court and in Supreme Court and in various other courts. And he has incorporated his own ideas for expediting the commercial causes. And we have been working the new act in the last 5 years and more. Some substantial amendments were again made in 2018 to the act. And I think on the whole, the experience has gained so far shows that it should be possible for the judiciary to reach justice to the consumers of justice more expeditiously than has been possible so far. If we look at the total number of cases which are pending in the courts in India, more than 1 crore of cases are civil cases out of about 3.8 crore cases which are pending. And in the high courts, there are only a very few high courts which have the original site. Most other cases are pending in the district courts and subordinate courts. But if we take only the High Court original site as it stood prior to the constitution of the Commercial Court, almost 50% of the cases were of the commercial causes, because they are mainly high value and relating to intellectual property, various other business transactions, etc., which will come within the definition of the commercial cause. Now, I think some of the important things, some of the important changes which are made as a result of introduction of the Commercial Courts Act with the amendment in 2018 can be traced to the subsequent report of Justice A.P. Shah, the Law Commission, presided over the chaired by Justice A.P. Shah, 253rd report, which took into account the previous report and the recommendations made by the committee constituted by the Supreme Court, and made these suggestions and suggest there was a draft law also enclosed, which thereafter came to be adopted. Now, I want to highlight 3 or 4 aspects of the Commercial Courts Act, which are very, very welcome changes. One is the pre-institution mediation, which has been brought about by an amendment in 2018, Section 12 capital. That's a very, very significant departure. Although Section 89 of the CPC has amended, the court referring the matter for arbitration or mediation, if the court felt that it was a desirable thing to do, if it was feasible. Here we had a mandatory pre-institution, pre-institution of case, mediation. The only exception made is where urgent interim orders are needed. Of course, today, I think there needs to be a greater check on this, because even where interim orders can wait for 4 or 5 months and the mediation can be completed in 3 months, sometimes the parties are resorting to institution of suit with an application for interim order, even without resorting to mediation. I think the courts which entertain the suit should discourage institution of suit without resorting to mediation if there was sufficient time for the parties to go through mediation before filing the suit. I think this is one, we should try to see whether we can avoid the very institution of a proceeding rather than after institution trying to resolve it. Second important aspect, I think, is in respect of the Parliament having taken note of various judgments of the Supreme Court, including Salem District Bar Association and Justice Ravindran's judgment in subsequent cases, where the court has felt a time has reached where we need to ensure that parties who file frivolous and vexatious litigation should be mulcted with exemplary costs. Equally, if the defense is bogus or vexatious, the defendant should be mulcted with exemplary costs. Therefore, Section 35 CPC, which imposed a kind of a limit of 3,000 or a few thousands, that has been amended. And provision has been made for actual costs being levied and recovered and paid over to the person who has succeeded, subject, of course, to various changes. The amended Section 35 makes provisions in regard to all these things. That is a very, very notable change. The third, the plaintiff or the defendant, while filing the plaint and written statement, used to merely verify the averments. Now the requirement is to take responsibility for it by an affidavit, because the moment you file an affidavit, its own affidavit, you are opening yourself to proceedings for perjury, and therefore it is intended as a deterrent. Simultaneously, the discovery proceedings have been tightened. Filing of documents along with the plaint and written statement, most of it have to be filed, including documents which may or may not help your case. Therefore, there is now a duty cast on the plaintiff or the defendant to file all documents in their custody which are relevant to the litigation, whether it helps them or not. Because there was a practice earlier of parties working these documents, and therefore, okay, you can draw adverse inference, that kind of a situation. But today, I think there is a heavier duty cast on the parties to disclose all these documents. And one of the reasons why this was done was the committee and the commission, law commission, had noticed that in the US, most suits don't go to trial. And most suits tend to get resolved at the stage of discovery. Once the parties know where the lie of land is, what the facts situation is, by and large, parties assess the chance of success, and on that basis, the lawyers advise the parties, and lawyers say what are the chances for them and what will be the consequences in case they lose in terms of costs, etc. the cost that they will incur and the cost that they may have to pay to the other side. And therefore, they take a pragmatic business decision. Most litigants are practical in these aspects, unless you have an interim order which you feel you can drag on for years. Nobody would like to hold on and then incur additional costs. And there are very few who are standing in terms of prestige for the purpose of fighting a litigation. There are a few, though, no doubt, who might not be willing to withdraw or resolve the issue and then call closure. This, I think, this discovery, the elaborate procedural provisions which have been made in regard to discovery, I think is a very, very important change, which, if successful, should be carried out in the entirety of the Civil Procedure Code, not only for the commercial causes, but for other causes. Another procedural part, apart from the pleadings and discovery, is in regard to the interrogatories. Although the provision has always been there, it was more in disuse than actively used. But I think after the commercial courts have come, I think there is a sustained effort by the lawyers to serve interrogatories so that they know where they stand. And the object being expeditious disposal of the causes. I think the lawyers have also been proactive in availing of these procedural provisions. Two other important changes which have been brought about. One is Order 13 capital A, which is in regard to summary judgment, and where the likelihood of success are assessed by the parties and the court, and based on that, without even having witness action, oral evidence, there is a procedure for going for summary trial, summary judgment based only on documents and arguments. This, I feel, has not been used in a proactive manner by the lawyers so far, but I think there should be a greater effort to avail of this, because there are a number of cases which can be resolved with a summary proceeding rather than going through an elaborate civil action. The power now vested of case management in the court which is handling the commercial cause is another important change which has been brought about. I think the experience of the English court and the American courts on case management as to how successfully the registrar or the equivalent, the master, have been able to give directions was one of the things that was taken into account by the committees and commission. In fact, here the power is vested directly in the judge. In some jurisdictions, it is vested in the judge. In some jurisdictions, it is vested in a kind of a court manager. We need an army of trained court managers. In fact, some of the law schools should focus on preparing some court managers, just as we need to train good judges for these aspects. We need also court managers who are trained in time and motion management, and therefore who would be able to ensure that considerable saving of time is achieved in regard to conduct of cases. And equally, I think there is a need for reskilling of the lawyers in regard to preparation of pleadings, filing of documents, and concise written submissions. I think this is needed. Therefore, when Section 20 of the Commercial Courts Act talks of training and continuous education, it has to be of the judges who are engaged in that, as also the lawyers. I think this is a very, very significant statutory provision which has been made in regard to training and continuous education, which should be adopted not only for the judicial officers, but also even for the lawyers. And I say this because Order 18, when it says mandatory written submission with limited oral submissions, the discretion is vested in the court as to how much of time will be given for oral submission. And I think the judges should be able to, after going through the pleadings and some of these issues, to evolve a time frame which should be definitely followed by the lawyers. They should keep it up, and so that in a matter of 2 to 3 hours, even cases of importance can be heard and disposed of. There is, after the amendment and after the commercial courts have been set up and have started taking up the matters, greater awareness amongst the judges, which I have seen not only in the High Court, but even in the district courts. I have appeared in the last year, even in the district courts through virtual mode, and most courts now have been equipped in the virtual mode. So they have got used to the virtual mode, 1. 2, they have got used to documents, convenient compilation being prepared, even though there may be 7, 8 volumes of documents. The counsel are able to present their submission with requisite pages, which are photocopied and then given, so that very concise, convenient documentation is followed, and quickly refer to them and make submissions. I have seen that the judges are able to go through this convenient documentation and the written submission and come ready and shoot questions. This is a very, very significant change that has taken place after the courts have started taking up the commercial causes under the Commercial Courts Act, and more particularly after the 2018 amendment. I think we are coming to a stage where if we are able to succeed in these high-value commercial causes, we can try to translate this into other commercial, non-commercial causes, but other civil action, and perhaps speed up the entirety of the litigation. We exist as lawyers for the purpose of delivering justice. When disputes arise, when people engage in any kind of relationship, whether commercial or otherwise, there can be property dispute, there can be family succession disputes, various other disputes. I think a number of such issues can be resolved by mediation. And if we make the mandatory mediation prior to institution of suit in respect of all causes, it will be a very big effort to cutting down the number of cases which are actually instituted. And the changes that have been made, I am not suggesting straight away we should implement it in respect of other civil cases, but we see good results in this. We need, of course, to train lawyers, and with the abolition of some of the tribunals which is being done now in regard to, for example, abolition of IPAB, etc., more cases are likely to come to the high courts or to other district courts taking up commercial causes, because even in the question of disputes in regard to patents, trademarks, etc., which otherwise used to be taken up by the some of the boards, that will now come to the courts. And I think it is a good thing, because personally, I feel that the tribunal system has not been a great success. Therefore, if we have commercial division, buildings division, intellectual property division in the high courts or in the district courts, I think it will be a better alternative. I think this is by and large a success, and I would like to hear the response from you and answer the questions from you. I'm thankful for the opportunity given to me to meet all of you and interact with you. I shall now look forward to interesting questions. Thank you.
Thank you, Mr. Vaidyanathan. It was a very enlightening speech. Let me also introduce to you my colleague, Professor Akanksha Kumar, who is also an assistant director in our center. So she has just joined us. So we will take the student questions now. Can you please type your questions in the chat? Some of you are also sending your questions in the group, so I'll just read them out for you if you wish to do that. But for the others, please type it in the chat box.
Good evening, sir. I'm sorry, my Zoom was malfunctioning a little bit.
That's okay, Akanksha. It happens. Okay, I think you can just type your questions. You know, I'm not sure the Zoom audio would work for everybody all the time, because I've muted the mics. Sir, but before the students ask any questions, I have a personal question about this. So what explains this time gap between the first report, which is the 188 Law Commission report, and 188 Law Commission report in 2003 was, I mean, I found it very strange, because it was in its tone like a large complaint that all our cases are going to the British and the American courts. So that was in 2003. The act came in 2015. So what exactly explains this time lapse? Is it something ideological or just plain sort of?
No, there are, after the 188th report, a bill was introduced. It was passed by the Lok Sabha. Then it got referred to the Joint Select Committee. And thereafter, the government changed, and perhaps sufficient attention was not paid to this. And once again, it was Mr. Jaitley who took up the lead in 2015, by which time the fresh reference was made to the Law Commission, and the 253rd report had come in. And there was a draft bill also which had been annexed to that. And based on that, the bill was introduced.
Any question on the chat box, please? I just received a question from the group, which pertains to the Vidhi report. Sir, if you know, there was a Vidhi report on the working of the commercial courts, and that report was actually not that positive. And especially they had flagged the fact that the case management system seems to be working at all, and the lawyers are not taking it seriously. So do you think it's a, yeah.
I think there is some justification for the criticism. See, I think as I said, there is a need for creating greater awareness amongst the lawyers and the judges in regard to how the case management system can ensure that you narrow down the issues and you cut down, even because one of the things that was frowned upon was having long affidavits of witnesses, which merely repeats whatever are the pleadings. And there is a provision which enables the judge to strike out, because ultimately a witness of fact will have to only to some specific points in respect of which parties have joined issue. There are a number of facts where parties, the contesting parties, which will admit there is no need for evidence in regard to that. Therefore, I think there has to be drastic pruning of the affidavits of witnesses. Time limit in regard to cross-examination will have to be prescribed and enforced, because here the case management, one of the essential things that is necessary to be taken care of is in regard to cutting down the duration of witness action, and also ensuring the limitation in regard to oral arguments. I think I would not fault Vidhi on that. There is scope for considerable improvement, but I think one area where I have seen parties have been able to take this seriously is in regard to intellectual property, and particularly in Delhi, the lawyers today have been able to ensure that some patent disputes have actually been tried and final judgments have come. You would notice that there are very, very few cases which have gone to trial in respect of patent, validity of patent, and have actually yielded the final judgments in India. In the entirety of our patent history, it is only in the last 3-4 years that you have been able to see, and I think Chief Justice Gogoi was also responsible in monitoring and ensuring. What has been happening is there is an enormous amount of time spent in regard to arguing the interim application for interim injunction, restraining infringement of a patent. And that is virtually a mini trial. And therefore, Chief Justice Gogoi, when an appeal went up to him, said, look, people have argued 25 hours, 30 hours, both sides put together in regard to an interim application. By this time, the entire trial could have been completed. So he called for data, statistics, etc. And I think it created a kind of awareness amongst the judges also. And thereafter, the rules were made. And Delhi High Court has made fairly stringent rules in regard to the case management, generally in regard to conduct of cases under the Commercial Courts Act. The amendments have been made to the Delhi High Court rules. And similar amendments have been made in some of the other high courts, including Madras. So I think there is a need. You need a different set of skills with the lawyers and the judges to conduct cases under the Commercial Courts Act. Then only it can really be useful.
Sir, so we have another question from our student Abhishek. Abhishek is asking if we need a separate cadre of judges for the commercial courts, since yes, since the one who have already served in the civil court system has imbibed this bad culture that there is.
The Commercial Courts Act, while vesting the discretion in the Chief Justice in regard to constituting the courts, has also said, having one or more consisting of, for the purpose of and so also, shall nominate such judges who have experience in dealing with commercial disputes to be judges of the commercial division. Subsection 2 of section 4. And appellate division also, subsection 2 of section 5, shall nominate such judges of the High Court who have experience in dealing with commercial disputes to be judges of the commercial appellate division. The parliamentary intent is clear in regard to having persons who have had experience in dealing with commercial disputes to man the court, both in the commercial division and the commercial appellate division, and equally in respect of the civil court, this will apply. And when it talked in section 20 of training and continuous education, of necessary facilities for providing for training of judges who may be appointed to the commercial courts, the intent is again clear. I think we need We need persons who can deal with, for example, turnkey contracts, building disputes arise. Unless you have a person who has some background in regard to some awareness of civil engineering, building, or in regard to finance and not just law, you would not be able to handle it successfully. Now, if you have intellectual property dispute on patent raising out a pharmaceutical patent or in regard to software, now the person should have that. Therefore, today you have law schools which have specialized courses. I think IIT Kharagpur, the technology institution, have started a course in regard to intellectual property. Therefore, there are engineers who are coming to law, like you have, I don't want to take names, but you must be aware, there are chartered accountants who have become lawyers and very successful lawyers, because in fact, some of the most successful lawyers today in the country are those who have a good background in finance, because then only they will be able to present the commercial impact of any decision, any dispute. Therefore, I think there is an acute need for unlearning some of the things that we have learned in regard to the commercial handling of cases and learning new skills. I think it's very, very essential. And I mean, there are several lawyers who are young and who are up, well up with the required skill. But I think some of the old school lawyers need unlearn and then reskill themselves. It is needed.
So before I move on to my colleague, Professor Akanksha Kumar has a question on mediation, that is the compulsory mediation. But before that, a very short cross question, sir. So do you think we need to appoint judges from now, say the law firms, the transactional side, from academia, from general counsels, like the whole process of who can be a judge in a commercial court? Should that undergo a change?
I have always felt that there has to be greater diversity in the judiciary. It is a sad commentary on our institution of judiciary that we have not had a single person from the academic field in the jurist category filling the office of the Supreme Court judge. I think we need to remedy this defect and we need to take in persons. I can from Delhi Law Faculty itself who could have become judges. Professor Tripathi, Professor Madhav Menon, Professor Bakshi, Professor D.P. Singh. They're all persons who would have filled the office of judgeship in the Supreme Court so admirably well. And I think, you see, when you sit in the company of several other judges and you are able to share your academic orientation and the amount of learning that you have acquired by reading, because the judges otherwise don't get to read so many of these articles and books, whereas an academic is trained and always on the lookout for new material, reads a lot, and then tries to grasp, understand, and put it over, because you are every day meeting students who are well up, who read up themselves, and it is a challenge to teach the students. Therefore, Ram Jethmalani as a lawyer didn't prepare so much for arguing a case, but for 1 hour of lecture, he used to read up for 15 hours. That was the kind of thing that he used to do. Therefore, any person who is a teacher, a good law teacher who has this skill, I think should seriously be considered for judgeship. I have always been of this view. equally persons who are in the industry or even in the transactional area, I think provided the requisite skill. You see, how do you assess the merit of a person? Therefore, you need diversity, because if you, for example, in the High Court and Supreme Court, which are exercising extraordinary jurisdiction of writs and public interest litigation, etc., where complaints go in regard to the government's failure on certain aspects. Now, unless you have gone through the mill, you wouldn't be able to understand the problems that the common man is facing. If you are sitting in an ivory tower, you can't possibly. Therefore, you need persons from diverse backgrounds. Now, for the gender equality. Now, the lived experience of a woman is very different. A lady judge perhaps would, of course, there are exceptions. The Nagpur judge who gave, I mean, that was rather unusual. But ordinarily, you would not expect a lady judge to ask a person who has committed a rape to marry a woman. I mean, the victim. This kind of because the lived experience is such, you would not perhaps have the patriarchal mindset once you live through this. Now, that's why I said, when we need diversity, to come back to commercial courts, you need persons who have been exposed to industry, business, who should come and man. Because if you have such background, training, experience, you will be able to resolve the disputes in a realistic, pragmatic manner, which is more acceptable. And that is what is needed. And that is why I have believed that even in respect of arbitrator and mediator, you need more non-judges, non-retired judges as arbitrators and mediators, persons who are worldly wise, who are practical in thinking in regard to resolution of disputes, not procedural thinking, not a technically pure technical law, legal aspect, but pragmatic thinking. And they would make more successful arbitrators and mediators, rather than our focus on these retired judges as arbitrators and mediators.
So thank you, sir. I'll just request my colleague, Professor Akanksha, to ask her question on compulsory mediation. I believe she has a question on that. Akanksha, please go ahead.
Right, sir. Good evening, sir. I just have a very short, quick question. I was wondering what your views are on the, if still ongoing discussions on the mediation legislation in India. And once this, because the pre-institutional mediation is mandatory, do you think that these pre-institutional mediations therefore would then be conducted under the procedure under the Act, or do they continue to happen ad hoc because the Commercial Courts Act is a more procedurally special legislation mandating the pre-institution mediation? And if you do have an opinion on the impending or not mediation legislation of India?
No, I must confess that I have not applied my mind to that legislation. Therefore, I would not be able to react. But I personally feel that, see, when we are talking about mediation, pre-institution mediation, perhaps it will be better if it is institutionalized under the court system. I mean, in the sense, each court today, most of the courts, high courts and district courts, have a mediation center. Therefore, it is easier for people to approach. Of course, it is not necessary that the lawyers should necessarily be participating in the mediation process. The parties should be able to approach it directly. And merely because it is an adjunct of the court system, it is not necessary that the lawyers should be involved. Parties should be able to resolve the disputes by going to the mediator.
Sir, I will take the next two questions. So one is from Pratyush, the other is from Abhishek. So first, Pratyush asks if it is going to be possible ever to just replace all the litigation with arbitration. And Abhishek asks, on the other hand, if we can have a hybrid model like that exists in the DIFC or the Singapore International Commercial Court. So can we have those kind of technologically savvy, mixed mode kind of systems in this country?
Yeah, mixed mode system we can, but I don't think we are ever going to replace litigation with arbitration or mediation. You see, the problem is one, mediation will have to be by consensus. It can't be forced down somebody's throat. Arbitration, I am afraid, in India has not been a great success. It has been extraordinarily time consuming. I think very, very expensive and also not very satisfying. If there is a three-member panel arbitral tribunal, each party nominating and a chairman being nominated, it is as if the tribunal, the member who has been nominated by a particular party feels as if he is obliged to ask questions in favor of the party who has appointed him. I mean, this is an unheard of kind of a situation. I think this is not something which is very encouraging from the perspective of arbitration in India. This mindset will have to change. People, if they nominate you because they consider you as a good arbitrator, what they should expect and what you should tell about, show them also is that you are absolutely independent arbitrator, uninfluenced by the fact that you are nominated by a particular party. I think that presumptive bias will have to go. As the mindset which is in favor of the party which has nominated you should go. That, I don't know, I mean, it's rather strange that persons who have lived through their life as judges for 10 years, 15 years, 20 years are having this kind of mindset. And even amongst persons who are retired Supreme Court judges, I have seen it. And that's a shocking thing. And I feel very, very disappointed that this should be happening at all.
Okay, sir. So I think what Abhishek was asking was about DIFC. So you see, international commercial courts have this method where you can convert a money decree into an arbitration award and enforce it. And now you also have the Hague Choice of Court Convention. So, I mean, the world is moving really fast, and in India, we are just trying to play catch up for that time. So, can we kind of replicate this system, sir, or is it a near possibility?
I see, the question is in regard to enforcement of award or in regard to execution of a decree or an award. Now, it has been said of India that you get away by getting a decree, but to execute it, it takes much longer time than you actually have spent in getting the decree. People take enormous amount of time. Now, what has happened is in India, the level of being satisfied with an arbitral award on account of the perceived bias of the arbitrator or otherwise is so high that I don't think there is acceptance of award without challenging it. Therefore, we are going through the same system, Section 34, Section 37 appeal, and then Supreme Court. There is no easy acceptance of the award. So how, I don't know, I mean, unless we are able to create a greater amount of confidence in the arbitrators and the arbitral system, arbitral tribunal, I think people have, even today in India, have greater confidence in the court system. We have seen the tribunal system also, the people's confidence in that is missing. They are able to have, as a lawyer, I can say, I have greater confidence in the High Court and in the Supreme Court rather than in the system of tribunal or in arbitral, specialist tribunal that have been created or the arbitral tribunals. This is the reality. And therefore, till such time as the confidence in the institution, the system is changed, I don't think we can move on to that. That's my view.
So, sir, I'll take the last question for now. I think, yes. So the last question is from Shudhanshu. So he's asking about the relationship with tribunalization, which I think you did touch in your speech, in your talk. So do you think if we continue to have this many tribunals, something like a commercial court is a general mechanism, right? It's a transubstantive mechanism. If you have every type of law, if you have a tribunal, will this ever take off? So what is the connection really?
The tribunal for, the specialist tribunal for commercial disputes, or what? I have not followed the question.
Yes. So the question is, for everything, we have a tribunal now. We have a tribunal for companies, we have a tribunal for competition, we have a tribunal for consumers, a tribunal for everything that anyone can think of. So the point is that a commercial court system or a civil court system for generally speaking, all suits of civil nature. So these are general mechanisms. Tribunals are specialized mechanisms. And if we continue to insist on tribunals, then will this ever take off? Because all the cases would be diverted to these tribunals.
No, I think we have a large number of cases in the civil courts, much more in the civil courts than in the tribunals. See, tribunals essentially started with legislation giving new rights and new remedies. When it created new rights, it constituted new fora for with new remedies. And that is how most of these have come about, like electricity or telecom or tribunals, etc. They were not dealing. Now, I personally believe all appellate proceedings from those specialist fora, the initial adjudicatory authority, should be to the High Court. Commercial or different divisions in regard to dealing with each one of these. And it will be much better because, see, the Constitution ensures that there is independence of the judiciary. That kind of a constitutional assurance is not available for any other tribunal members. Most tribunal members are selected from out of the bureaucracy or from amongst retired judges. They are not persons who are recruited in the first instance, and they are not having the same kind of guarantees in regard to their service that a normal civil court, or in particular the constitutional courts like High Court and Supreme Court have. So my level of confidence in those kind of courts is much, much more than in any tribunalization.
Okay, so I think that's the end of the student questions. So, and we are also exhausted our time. So thank you, Mr. Vaidyanathan, for joining us as a speaker, for illuminating us on this very interesting topic, because our students are going to, like what I tell them every day, that they are going to inherit a very different world than what even we started. And world, it is changing very fast. I mean, before 2019, I don't think we really bothered about Zoom and time software at all. And in fact, last 2 years, we have not studied law so much as we have studied technology. So, so we don't know like where the world would take us, and things are really changing fast. If anything, India is probably not changing in a space, it is going to change. So thank you, sir, for your speech. I thank the students for participating, and also thank our IT team for organizing this so well. So thank you, sir. Have a great evening, and we will once again like to have you someday. I hope that would be, you can join us some other time as well.
Thank you, and best wishes to all of you. Thank you.
Thank you, sir.
Okay.
Thank you.
Thank you, sir.